हेलो दोस्तों, आप लोगों का स्वागत है हमारे चैनल टेक लवर्स पे। आज हम लोग डिस्कस करेंगे कॉन्ट्रैक्ट लॉ के क्वेश्चन के बारे में। सो दिस इज वेरी एसेंशियल क्वेश्चन, लाइक दिस इज वेरी बेसिक क्वेश्चन। व्हाट आर द एसेंशियल ऑफ ए वैलिड प्रपोजल? एक्सप्लेन विद द हेल्प ऑफ रिलेवेंट केस लॉ। ओके, सो चलिए शुरू करते हैं। सो ए वैलिड प्रपोजल इन द कॉन्टेक्स्ट ऑफ कॉन्ट्रैक्ट लॉ is an essential element of the framing of a contract. To be legally binding, a proposal must be meet with a certain criteria. These criteria are often outlined in various law and statutes as well as established through case law. Okay, so I'm explain the essential element of a valid proposal and provide an example to illustrate the element. Okay, so let's start. And like a proposal क्या होता है? The term of proposal has been defined in section 2A of the act as when one person signified to another his willingness to do or abstain from doing anything with a view of obtaining the assent of the other to such act or abstentions. He is said to be make a proposal. Okay, for example, a is willingness to sell his radio set to B for rupees 500 with the intention to consent of B. But if a statement is made without any intention to obtain the consent of the other party thereto, that cannot be termed as a proposal. Okay, so this is the example. And element of the proposal क्या expression of willingness to do or abstain doing something made with the object of obtaining assent of other. Okay, thus the person making the proposal is called the proposer or offeror or promiser, and the person to whom the proposal is made is called to the proposee or offeree or promisee. So यहाँ पे क्या है कि जो आपको व्यक्ति प्रपोजल दे रहा है, प्रपोज कर रहा है, उसको हम प्रपोजर कहेंगे या ऑफर कहेंगे या प्रोमिसर कहेंगे, और जिसको ऑफर कर रहा है उसको ऑफरी या प्रोमिसी कहेंगे। ओके, और इसका बेसिकली पर्पस क्या है कि प्रपोजल या ऑफर करने का कि जो अदर पार्ट पे जो दूसरा व्यक्ति है उसकी एसेंट लेना, उसकी कंसेंट लेना। ओके, अगर वो उसको एक्सेप्ट कर लेता है देन फिर कॉन्ट्रैक्ट बढ़ेगा। सो ऑफर मस्ट बी कम्युनिकेटेड। अब जो आपने ऑफर दिया है, तो सेक्शन 2A ऑफ द एक्ट एक्सप्लेन दैट द पर्सन इज सेड टू बी मेक ए प्रपोजल व्हेन ही signifies to another person his willingness to do or to abstain from doing something. The emphasis here is upon the requirement that the willingness to make a proposal should be signified. The term signify means to communicate or make known. It thus required that the offer must be communicated to the other person. Okay, and essential of a valid proposal: intention to create legal relationship. Okay, the proposal must show a clear intention on the part of the offerer, the party making the proposal, to create a legal binding contract. If the offerer intention is not clear, the proposal may not be valid. The case law example that illustrate this principle is like Balfour versus Balfour 1990s का case law है. In Balfour versus Balfour, the husband made in agreement to pay his wife in allowances while they were separated. However, the court held that it was not a legally enforceable contract because it lacked the intention to create legal relations. The agreement was considered a domestic agreement rather than a legally binding contract. Okay, so define and certain term. Then second जो essential है, the proposal must be contain definite and certain terms that allow the offeree to party receive the proposal to understand the terms and condition of the offerer. If the terms are vague or uncertain, the proposal may not be valid. For example, the case law is there. Scheme Well versus Austin 1941 का केस लो है. In this case, the defendant offered to sell the plaintiff a lorry truck for certain price on higher purchase terms to be agreed. The court held that the proposal was too uncertain because he did not specify the term of his hire purchase agreement. Therefore, it was not a valid proposal. So ये भी है आपकी जो condition and terms and conditions है, these should be definite and certain. It's not like vague conditions. Communicate to the offeree. So the proposal must be communicated to the offeree for it to be valid. The offeree cannot accept an offer they are unaware of. The case law is example to demonstrate this point. Okay, the case law is Carlyle versus Carbolic Smoke Ball Companies 1893. In this famous case, the Carbolic Smoke Ball Company made a public advertisement offering a reward of anyone who used their product as directed but still contracted influenza. Miss, Mrs. Carlyle used the product as directed and still got sick. The court held that the advertisement was a valid proposal and Mrs. Carlyle was entitled to reward because the offer had been communicated to the public. Okay, so not to be revoked or lapsed. And a proposal should be open for acceptance by the offeree until a valid acceptance is made or until the offeree revokes it. If a offerer withdraws the proposal before it is accepted, it becomes invalid. A relevant case illustrates this point as well. Berlin versus Van Steinhoven 1880 case law. In this case, the defendant is Cardiff sent in offer by letter to the plaintiff in New York. The plaintiff accepted the offer by telegram, but the defendants had already sent a letter to revocation before receiving the telegram. The court held that the acceptance was valid because it was communicated before the revocation, making its binding contract. Completion of communication. So completion of the communication is also the section 4. The communication of a proposal is complete when it's come to the knowledge of the person whom it's made. An offer cannot be accepted unless and until it has been brought to the knowledge of the person to whom it is made. For example, A cannot said to be an offer to B unless A bring to the offer to the knowledge of the B. Okay. Thus, acting is ignorance of an offer does not amount to acceptance of the offer. एंड एक केस लो और मैं आपके साथ डिस्कस करना चाहता हूँ. इन लक्ष्मण शुक्ला वर्सेस गौरी दत्ता, द प्लेंटिफ वाज इन डिफेंडेंट सर्विस एज एन सर्वेंट. द डिफेंडेंट nephew absconded and the plaintiff went to find the missing boy. In the plaintiff absent, the defendant issued handbills offering a reward of 501 rupees to anyone who might be find the boy. The plaintiff traced him and claimed the reward. The plaintiff did not know the handbill when he found the boy. The court held that the plaintiff was not entitled to reward if the person was the if the person has the knowledge of the offer, he is acting in accordance with the terms, therefore the amount of the acceptance of the same. In such case, it's immaterial that at the time of accepting the offer, acceptance does not intention to claim the reward mentioned in the offer. Okay, so if you like the video, please like, comment and subscribe the channel. This